Let me know when you're ready.
Okay.
1 second. Now my turn to.
Yes.
Okay. All right. Good morning, Ms. Rivers.
Good morning.
You ready to take a plea down?
Yes, I am ready.
Great. This is 25 SC 006-718, State versus Ms. Collier. Ms. Collier is here with Ms. Rios as her lawyer. Ms. Willingham is here for the state. Ms. Collier, to go through a guilty plea, you have to be sworn in. Ms. Willingham will do that. Once you're under oath, you're going to need to answer some questions about your rights and about your case. I need you to do that, but I also need you to let Ms. Rios or me know if you have any questions. If we start talking about something that doesn't make sense, or it's not going the way you thought it was, call a timeout and say, wait, could you explain this? I need to make sure you tell me if you're confused by something. Will you do that?
Yes.
Yes, okay. And when you're answering questions, make sure you answer out loud. The court reporter can take down only the spoken word. I know you can't see her. She's invisible.
Oh,
she's virtual, so she can see you.
Okay.
She's working from the home office today, but she creates a record based on what's spoken. So you're welcome to nod your head or shake your head, but words need to accompany that.
Okay.
All right? Ms. Willingham.
Good morning. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Tanya Caprice Collier.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medication.
And what kind of medication is
I
that?
take 8 different kinds for hypertension and large heart and arthritis
Does any of
and
that,
mental.
I'm sorry, repeat the last thing and then I'm going to ask you a question. That last part.
You said you take it for large heart, and then you
And
said,
large heart
and
severe hypertension, arthritis, and depression.
And does any of that medication alter your ability to understand what's happening today?
No.
Okay. How old are you and how far have you gone in school?
I'm 64. I graduated from high school.
And are you able to read, write, and understand the English language?
Yes.
Ms. Rios, have you had the opportunity to review the indictment in this case with your client?
Yes.
Do you waive formal reading of the indictment?
Yes.
Ms. Collier, do you understand that although you are charged with aggravated assault, possession of a firearm or knife during the commission of a felony, the state will be null processing count 2, which is the possession of a firearm during the commission of a felony, and we will be reducing count 1, aggravated assault, to disorderly conduct under OCGA 16-11-39, and you would be entering a guilty plea to that count for 12 months probation, and you would be required to have no violent contact with the victim, complete family violence intervention program, and complete 60 hours of community service and have no weapons?
No. I'm gonna say guilty.
well, she wants to make sure you understand that's going to be the negotiated
Oh,
resolution.
yes.
That's not a surprise to you. 12 months probation, all those conditions. You understand those are what you've agreed to do.
Yes.
Okay.
Okay, and have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
And do you need any more time to discuss this case with your attorney?
No.
Ms. Rios, have you had the opportunity to advise your client of the minimum and maximum sentence of disorderly conduct?
Yes.
And Ms. Collier, you understand that minimum sentence is 1 day and the maximum is 12 months in custody? The possibility?
Yes.
Okay. Do you understand that this is a negotiated plea negotiated plea of guilty, which means the state and your attorney will make a sentence recommendation as just explained to you just a moment ago. But the court does not have to accept that recommendation. The court can sentence you to the maximum sentence as we just discussed, which is a 12 months in custody sentence.
Yes.
But because today is your final plea, you have the right to, if you do not agree with the court sentence, you can withdraw your guilty plea today. Do you understand that?
Yes.
And are you on probation or parole for anything, anywhere?
No.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Guilty honor or offer.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Are you still asking the court to accept your plea as a guilty under Alford?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA section 5-6-35.
Yes.
And I'm sorry, I'm going to go back. Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, and the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved by the state beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Okay, and Your Honor, if this case were to proceed to trial, the state would expect to show that on October 23rd, 2024, East Point police officers were dispatched to 2360 Dello Drive, apartment 15 in Fulton County for a domestic dispute between Ms. Collier and her live-in boyfriend, Mr. Thomas. Mr. Thomas told officers that during the argument in their kitchen, Ms. Collier became angry, began throwing items, and then picked up a kitchen knife and waved it towards him while stating that someone needed to call the police or she would kill him. Mr. Thomas stated he was afraid for his safety and she made those threats while holding the knife. Mr. Thomas's grandson, KD, witnessed the incident. He reported that he saw Ms. Collier retrieve a knife from the drying rack beside the kitchen sink, hold it with the blade pointed toward Mr. Thomas, and pace back and forth while repeating that she would kill him if police were not called. Both witnesses independently confirmed that Ms. Collier brandished the knife and made verbal threats to kill Mr. Thomas. Your Honor, I have had an opportunity to speak with Mr. Thomas very briefly. Actually, we attempted to call Mr. Thomas initially, and Mr. Thomas called us back while with Ms. Collier. They actually contacted my investigator back. And during that call, we learned that the couple had been together for quite some time. Mr. Thomas states that although the knife was pulled out, it wasn't really pointed at him. He stated that it was more so kind of like down to the side. Although we recognize that we could still use his original statement to law enforcement. based on the age of this case as well, the state determined that as the parties have not had any other issues since then, that this was a fair and reasonable resolution. And I believe Mr. Thomas is present in court today.
Hello, Mr. Thomas.
Hello, how are you?
I'm all right. You and Mrs. Collier been talking for a while?
19 years.
19 years.
Been together 19 years.
Why don't you make it official, Mr. Thomas?
Well, I'm 70 years old, so
There you go.
I'm down here now.
Are you okay having Miss Collier around?
Of course.
Sometimes it gets a little bumpy. All right. One of the conditions that the state has asked for is no violent contact. So the two of you can still be together, but if you get into arguments, Ms. Collier needs to walk away and not throw something or say something or wave something around. And you need to feel free to reach out for help if something escalates in that way. Do you work?
No,
You're retired. What do you used to do? All right. Does Ms. Collier work?
no.
You guys get retirement benefits or? Excellent. Okay. 19 years. I appreciate you being here. Anything else?
Nothing further, Your Honor.
All right. Criminal history information.
Can she? I don't know. Can she?
I'm not sure. Belt it out. Thank you.
You got 4 cycles, 2012 ag assault, possession of a knife during the commission. I talked to the state, it's dismissed.
It,
It was
It
an
was-
immunity motion,
Oh.
and she succeeded on that.
got it. It's interesting. It's similar charges. Who was the person you were mixed up with in that case from 2012? Mr. Thomas. Huh. All right. So this wasn't the first time.
Quite a few years ago.
Yeah. Okay. All right. That's it. Thank you. Okay. Maybe you both should go to family violence intervention, but it's your case, not Mr. Thomas's. All right, Ms. Rios.
Yes, Your Honor. Ms. Collier is 64 years old. She does have a lot of stuff going on with her health that she's struggling with and her mental health, and that's why she's on disability for those things. She has 5 grown children, and she currently takes care of her father who had a stroke. I just ask that you go along with the negotiated plea and waive the fees.
All right. Ms. Collier, your father, I'm sorry about the stroke.
Yes.
When you're taking care of him, is he living with you or?
Yes, he lives with me.
Okay. And do you and Mr. Thomas live in the same place?
Yes,
So the three of you and Mr. Thomas and your father are all in the same place?
yes.
Your 5 kids are all grown? Are they local so they can help out or are they far away?
They come and see, they come and they most every day.
Okay.
They call me 3 or 4 times a day.
Good. So
But
they
they
take
all
that.
done graduate from college.
Good.
I got one going now for city, what is it, Councilman, District 62, my son.
Fantastic.
Yes,
Well, good kids.
Yeah.
And they're there to take care of you if you need it.
oh, yes.
Okay.
They get someone too, but they work a lot.
Yep. Okay. Do you have any questions about what we discussed?
No,
No? Okay. You and Mr. Thomas need to, even after 19 years, come up with ways when you're having a disagreement, and you're going to have disagreements, to do it where it's words and not more than that. And that may mean people need to take a walk or go
Yes.
for a ride or just go to the other end of the house.
Yeah.
But if something like this happens again, we've got the case from 2012, and I appreciate it was dismissed. There was an immunity motion, but that's still the two of you
Yes.
getting into it.
Yeah.
We got this, and that's not bad. That's 12 years apart. That's 12 years where the police didn't have
and
to
the
show
last
up.
time,
Pardon me?
and this is the last time.
Okay, well, good. You guys do your best to try to talk it through. If I had been there on October 23rd of 2024 when this happened, would I have seen that people were drinking? Did that contribute to it at all?
Probably so.
Okay. Well, here's what I'm going to do, Ms. Collier. First, I find there's a factual basis for your plea. I know it's an offered plea. You're saying, hey, it didn't happen quite like what the prosecutor's saying, but you've decided it's in your best interest to take the plea.
Yes.
I find that the state could still probably prove this up, given what was said at the time, especially the grandson saying, I saw her with a knife, it was pretty scary. That might not go so well in front of a jury for you. But you're resolving this, so I'm going to accept your plea. I also find that your plea is knowing, meaning you've understood what we've talked about.
Yes.
And voluntary, no one's forcing you to enter the plea. You agree with that?
Yes.
Okay. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
And Ms. Collier, can we sign your name to the indictment indicating your plea to the misdemeanor?
Yes.
We'll do that. I'm going to follow the recommendation. I'm going to add one thing, but it's going to be 12 months probation. Special condition number 1 is no violent contact with Mr.
Yes.
Thomas. You can hug on him all you want, but you can't hit him with a rolling pin or wave a knife at him.
Yes.
You're going to need to complete the family violence intervention program, and that you're going to need to enroll in within the first 2 months. So you got 2 months to get started with that program. That's not just one class, it's actually a series of classes, and you may want to drag him along to the classes.
He will.
But you're going to need to provide proof of enrollment within the first 2 months of probation. I don't want you waiting until month 11,
Yes.
because then you won't finish it. You also need to do 60 hours of community service, and you should talk with probation about where to do it. I don't want it to be something, given your health, where you're not going to be breaking rocks or picking up heavy things.
Yes.
But it could be as simple as you're working in a soup kitchen, helping serve food for folks who need the food, or wherever you can do volunteer work where they can document it. And you need to do that within the first 6 months of your probation. So again, you're not waiting until the end, but you got 6 months to knock out the 60 hours. And the thing I'm adding is that I'm going to direct that you submit to a drug and alcohol abuse evaluation.
Yes.
And that's just going to be a medical professional who talks to you about how you live your life and what you put in you. And if that person recommends treatment, that treatment is going to be part of your probation, whether that's going to meetings or seeing a doctor or whatnot. But if part of making you healthier would be addressing, hey, maybe you drink too much, you drink too little, whatever it is, let's have someone who knows about that talk with you about it and figure out, is there some work that could be done there?
Yes.
I will waive your probation supervision fees, given that you are on government assistance. No point in moving it from one pocket to another. You will need to report to probation when they reach out to you. That form that Ms. Rios and you are going to fill out in a minute is going to have all your contact information. They're going to call you or email you. I don't know which way they do it, but they reach out to you and they'll let you know how to connect with them. Don't miss that first meeting, because they reach out to me saying, we can't find this lady and we got to do a warrant and all those things. Okay. Ms. Willingham, anything else in this case?
No, Your Honor.
Mr. Thomas, this is your chance. Any other conditions of probation? You want to make sure you get pot roast once a week?
Yeah.
Yeah, can't do that, sorry. Yeah, Ms. Rios, anything else on behalf of Ms. Collier?
No, Your Honor. Thank you.
All right, Ms. Collier, good luck with things and take care of yourself.
Thank you.
Go see. No, that's out at the.
Well.
At the hand of Stephanie, we're done. Bring your kids